force majeure and its implications in the times of COVID-19. Now, there are among the members of the audience today, you have lawyers and law students, and apart from that, there are also entrepreneurs and business people as well as corporates. And this is a very relevant topic in the current scenario, because once this thing dies down, there are going to be legal issues, and it is important for us, both as lawyers and non-lawyers, to understand what this means. So the presentation will be on a very simple format. It is not too much of legalese. The idea being to also inform the non-lawyer community about what force majeure means to their businesses, and also for lawyers to deal with this issue as and when they get to deal with clients who come up with this particular issue. Now, you see, force majeure is an expression which you find in every contract. It may be either specifically incorporated into a contract, and many a times it is not explicitly stated in the contract. So we have to understand what are the implications of such a clause, and in the absence of such a clause, what happens. We are living in a fragile world, and how an inanimate piece of nucleic acid can disrupt our very existence and the things we cherish. So this is a good time to take a practical assessment of our own selves and get enlightened and calibrate and recalibrate our lives and live in a society to prepare for such consequences in future. You see, the interesting part is that COVID-19, at least for the purpose of today's debate, is a force majeure issue. But assuming it becomes a matter of everyday existing reality, it would not be a force majeure event, because it is something which we have to live with. So it does not become a force majeure event. So let us all pray that COVID-19 comes and goes as an unforeseen incident in our lives. So the question is that we all know that we have seen it for ourselves, that how it has disrupted our everyday life. So it is obviously, to all of us, it is something so unbelievable and unprecedented that we would all be, in our daily lives, we would assume that this is a force majeure. But legally speaking, it is a debatable issue. Whether a COVID-19 outbreak is a force majeure or not, legally is a very, very debatable issue. Now, let me first deal with the origins of force majeure. You see, force majeure in French means superior force, and its Latin equivalent is vis major. This primarily means an act of God. So therefore, you identified it in its origins as something which is attributable to God. The usual things, you know, natural calamities, weather conditions, etc., earthquakes. But with the modern state evolving, it has begun to encompass a lot of other things. So much so that often a change of law, a sudden change of regulatory law, is also treated in various contracts as an act of force majeure. Now, force majeure, as we all know, is relevant to contracts, and contracts have evolved. The law of contracts evolved from Anglo-Saxon jurisprudence, and which is normally known as common law. Now, common law evolved out of various proclamations of kings in England, and then later on, when they came out with judicial systems, recorded judgments of courts contributed to the development of what is commonly known as common law. Basically, these are principles of law based on precedents. And perhaps if you go back to the medieval times, and you would find that trading was the primary commercial activity and they were inherently risky. So you would have people having to travel through alien territories, hostile people, weather. You have to go by ships through uncharted seas. And there was always inherent risk involved with businesses. And that is how the whole concept of force majeure developed. Because what it means is that, yes, business and trading activity can get disrupted by unforeseen possibilities and events. But you know, the interesting part is when in the English law, though they evolved with this concept, they evolved the concept of a force majeure, they were very, very, very thrifty by extending the benefits of force majeure in cases that came up before them. And English courts were virtually heartless. And they would say that, so what if that particular event happened because of not the fault of either of the parties, but the performance of the contract is so sacrosanct that you would still have to bear the natural consequences of the breach of the contract. That is, even though the event which has happened, which has prevented the contract from taking place, has happened because of actions not attributable to either parties, the non-performing party would still have to bear the consequences of a breach of contract. Now, this particular principle appears to be on the ancient belief that when parties enter into a contract, they are entering into a risky territory. They are taking upon themselves unforeseen risks. So if you're willing to take the risks, you can enter into a contract. But in 1863, in a judgment called Taylor versus Caldwell, the English court for the first time became attuned and realized that, yes, this could be somewhat improper and not very fair, that if something happens because of the intervention of an unforeseen situation, why should the other party bear the consequences of something which is not of his own doing? Now, this Taylor versus Caldwell was a case where a musical group was contracted to play at a music hall at specified days of the week. Now, one day it happened that by accident, the music hall was burned down in an accidental fire and the music hall ceased to be in existence. So this was a context in which the court came to the conclusion that when you don't have the musical hall, where is the question of a contract being enforced? Because the place, the site is where the contract was to be performed, is no longer available not because of the conduct of any of the parties, but because of a completely unforeseen circumstance. So that was a turning point. And in 1863, the English court held that if the contract cannot be performed because of supervening events, that is unforeseen events which happened after the contract came into existence, then the performing party, the party was supposed to perform the contract, is absolved of its contractual obligations. Now, force majeure today is an integral part of all contracts, as I told you. Now, what are the types of force majeure which you can contemplate under law and otherwise? You see, originally, as I said, force majeure covered only acts of God, that is natural calamities. But with the increasingly complex world of commerce and trade, these definitions have become enlarged or restricted, and they can broadly be classified into the following. The first is what is called a non-political force majeure. Now, what is a non-political force majeure? It is a force majeure clause which has been drafted by draftsmen to take into account certain foreseeable events which are not attributable to natural causes. For instance, non-political force majeure would include it would include something like non-political would be non-political would be the natural calamities like storm, tempest, earthquake, floods, tsunamis, etc., etc., and including pandemics and epidemics. These are what is called non-political, which is not man-made, which means acts of God, the pure and simple force majeure event. Then you have got what is called political force majeure. Political force majeure are events which could be attributed to men, that is some kind of sanctions, riots, strikes, insurrection, terrorist action, or changes in law, which I was referring to earlier. So these are all man-made, unforeseen but man-made situations, but not attributable to the parties of the contract. Then you have something which is totally different kind of force majeure, that is, let us say, a plane flying, a commercial aircraft flying from Australia to, let's say, London, and in between the aircraft suffers from a mechanical failure and it has to land, and the nearest airport appears to be North Korea, which is an enemy country. So you would have to put down the aircraft in an enemy territory where you otherwise don't have the legal permission to land. So that's a force majeure event which the international law recognizes, a force majeure of this nature, which allows a country to dock its ship or land its aircraft, etc., in an alien territory or an enemy territory in situation. This has happened in the recent past as well, but we need not deal with it. But then interestingly, there are also contracts where you don't have any force majeure clause at all. These are contracts where consciously the parties say that we will not have, or one of the parties says that I will not have a force majeure clause in my contract, because a contract is so, it involves very high value risks, or it involves a particular object or subject matter which is very expensive, and which does not, where a force majeure clause may completely destroy the very fundamentals of the contract. Now, this is, for instance, this applies to leases of aircraft, like commercial aircraft, which many airlines don't purchase aircraft, they take it on lease from finance companies. Now, finance companies buy these aircraft from manufacturers to whom they are liable to pay installments, etc., for the purchase of those aircraft, and they in turn then lease it out to airlines. Now, these kind of contracts are called, interestingly, hell or high water contracts. Hell, these are hellish contracts. These are contracts which do not give one of the party, the other party, any leeway to get out of the contract. So even if that aircraft crashes or it is not able to operate for a long period of time, the contracting party, the lessee, has to pay the contractual obligations, the installments under any circumstances. It could also be, for instance, a developer who's offering his prime property to a hotel chain on lease, and the developer has built this property in a beautiful place, and he has paid a high premium, and he has to service the loan that he took for constructing that structure. In such cases also, you have these kind of hell or high water contracts. So it is, a clever draftsman will always find ways to cover up for all kinds of, to reduce or narrow down the scope of a force majeure clause. But the point is that even if you don't have a force majeure clause, there can still be situations where a party can invoke force majeure. How does that happen? Now, this happens because of law. Now, the interesting part is that in Indian law, force majeure principles are incorporated into the statute law, the Indian Contract Act. And you see, the English law from which this principle has evolved, they still do not have any statute or a definition of what do you mean by a force majeure. But in India, you have a codified law, that is a law of contracts, where force majeure principles stand incorporated into the law. Now, the Indian Contract Act is an act made by the British, and there are only three substantive provisions that we need to be looking at. Now, there is something we have to go to the definition section 9, which deals with the express or implied promise, and then you have chapter 3, which deals with contingent contracts, which is and particularly we will be looking at section 32. And then you have section 56, which talks about frustration of contracts. Now you see, section 32 is a very simple provision. It is something which even a lay person can understand. What section 32 says is, contingent contracts to do or not to do anything if an uncertain future event happens cannot be enforced unless and until that event has happened. Now what it says is, a contingent contract is something which can be enforced only if something which is to happen in future happens or does not happen, and it cannot, until that particular future event happens or does not happen, the contract cannot be enforced. Now it may seem somewhat confusing to some, but what we are really looking at is a second line of that provision, which says, and this is all that we have to deal with, if the event becomes impossible, such contracts become void. Now, if you have a contingent contract which has to be performed only on the happening or not happening of an uncertain future event, then the contract can be enforced. But if that event, that uncertain future event, becomes impossible, such contracts become void. Void means what? What do you mean by void? Void means it cannot be enforced at all. Now, what is crucial here is to understand what is the meaning of the word impossible. Now, impossibility, what do you mean by the impossibility of performance? That's the scope for discussion as far as section 32 is concerned. Now, this meaning of the word impossible and section 32 generally came up for discussion in a very landmark Supreme Court judgment in 1954, which is Satyabrata Ghosh versus Mugni Ram Bangur. Now, this is a judgment of 1954. Now, what had happened in this case is that the plaintiff, that is the person who wanted the contract to be enforced, entered into an agreement to sell with the defendant, who was a builder, who was a developer. Now, this developer was making a layout or township where he was supposed to make roads and drains and also develop plots and sell it to people like Satyabrata Ghosh. Now, they entered into this contract. Satyabrata Ghosh paid an advance amount to the builder, and the contract for an agreement to sale came into existence. Now, after some time, the government took over that particular land. It requisitioned the land because this was in the backdrop of the Second World War. So the lands were taken over for the purposes of the defense of India, and the lands were not available to the developer. It was requisition. Now, requisition is a temporary takeover of the land. So the builders gave the option to the purchaser that, see, this is what has happened. So I am giving you two options. Either you take back your money and both parties are relieved of their contractual obligations, or second, you wait till the time the contract, the requisition is withdrawn, but then I am not under any obligation to give you the land. I will take my own time, etc., etc. And if you are not accepting both these offers, then I will forfeit the amount that you paid me as the advance. Now the matter traveled through the lower courts, etc., and finally came to the Supreme Court. Now the question was whether the defense put up by the builder that, see, there is an impossibility to perform the contract because of the requisition, and I am not at fault. The government has intervened and taken over my land. I can't build on it. I can't do anything on it. So I am absolved of my obligation under the contract. This is a clear case where section 32 is attracted and the contract has become impossible of performance. Now the Supreme Court said, no, this is not a case of impossibility. And the Supreme Court gave reasons. And it said, first it went on to the interpretation of section 32, and he said, section 32 involves a situation where the contract is not capable of being performed not because of the impossibility in the literal sense, but in the legal sense, in the sense of the contract not being capable of being enforced. So it is because of something which is to be found within the contract itself. What is that impossibility of performance of the contract? It is not like a flood or an earthquake. This is something which can be seen. The land was available, it was supposed to be developed, but there was a requisition by the government. So yes, there is an impossibility in the normal literal sense, but not a legal impossibility. Why? Because the court said that, number one, this was not a transaction for sale of one single plot of land. The developer, the builder, the defendant was actually selling a whole township, and it was not several other plots involved. It was a complete layout to be made, and the entire lands were not requisitioned. Only parts of it were requisitioned. Number one. Number two, the court looked at the contract and said that the contract nowhere says that this has to be performed within a particular time period. It is not framed in a particular time frame network that if it does not happen by such and such time, then the parties are relieved of their obligations. There is no time limit. And then the court also noted that the requisition by itself is a temporary measure. It is not something of a permanent nature, which would render the execution of the contract impossible in future. And then on facts, it also noticed that you see the period from the date of the execution of the agreement to sell and the first requisitioning order issued by the government was 15 months. Over a period of 15 months, the developer himself did not carry out the development of the roads and layouts and the drains. So therefore, he was also, in a manner of speaking, he was at fault. So he cannot be allowed to take advantage of his own fault and his inability or failure to do his part of the bargain. Now the court then held that the word impossible has not been used in the sense of physical or literal impossibility. The performance of an act may be literally impossible, but it may be impractical and useless from the point of view of the object and purpose of the parties. If any untoward event or change of circumstance totally upsets the very foundation upon which the parties entered into their agreement, it can be said that the promisor finds it impossible to do the act which he had promised to do. Now, I'll give an example here in the very same set of facts. Instead of a requisition, if it was an acquisition, because in the case of an acquisition, it is a government's exercise of power of eminent domain. It has taken over the land, the ownership of the land now rests with the government. In such a case, the builder can very well say that I cannot be called upon to execute this contract because there is an acquisition of this very land which belonged to me by the government. So how do I execute the contract? So this is a section 32 illustration. Now I'll also give one or two more illustrations to explain section 32. Now this is actually an illustration given in the act itself. Now A enters into a contract with B that he will pay, that is A will pay B a particular sum of money if B marries C, right? A says to B that if you marry C, I'll give you a specified sum of money. But unfortunately, C dies. The contract is impossible to perform. You see, obviously, this particular illustration is given at a time prior to the Hindu Marriage Act and all that, because you are treating a woman like a piece of goods. This is today improper, politically and otherwise speaking. But that is how this gives you a clear explanation as to what section 32 means. You see, why I am pointing out to section 32 is that the other section 56 deals with a different situation, but both of them deal with force majeure in different kind of circumstances. But section 56 deals with frustration. That is also one aspect of force majeure. Now, another example of 32 could be that, X enters into Y with a contract for purchase of a particular equipment manufactured by an American company. And the contract requires Y to procure that equipment from the company in the US, and it has to be delivered by ship. Now, soon after this, a contract is entered into, the American company, which was the manufacturer, ceased operations and goes into liquidation. Obviously, the contract cannot be performed. So this is what section 32 entails. It deals directly with the impossibility of performance of the contract in the context of the contract itself, the nature of the contract itself. So that is section 32 for you. And then there is a note which I have prepared, which I'll, of course, you can see it on the screen as well, where I've extracted the relevant portions of the judgment, etc. Now we come to section 56. Now 56 deals with frustration of contracts. Now this section is slightly longish, so I will not read the section itself, but the judgment, the 1954 Supreme Court judgment, which I referred to, also deals with section 56. Now, what section 56 talks about is the impossibility of performance of a contract because both parties, without due reasonable diligence, did not know that something would happen, right? So if something which was to happen was not, which the parties could not have foreseen would have happened, it could be, for instance, a change of law also. When they entered into the contract for purchase of a property or a sale of the property, the law did not prohibit the sale of that kind of property. But then after they entered into the contract, by virtue of a change of law, it became illegal to transact in those kind of properties. So that is one kind of situation. And 56 also deals with the vis majeure, that is a force majeure, pure and simple, that is act of God, etc. All those kind of situations of frustration of a contract are dealt with under section 56. Now, I also want to refer to another very recent judgment of the Supreme Court in what is called Energy Watchdog versus Central Electricity Regulatory Commission. This is a judgment of 2017. Now here I'll give you an illustration of section 56 kind of a force majeure event. Now what happened was various companies bid for supply of electricity to state electricity boards, and the terms of the bid were that they said our bid would stand regardless of the variation in the prices of the raw material or input cost. We will not claim any benefit of variations in input costs, etc. We will not resile away from our bids. Now, based on those undertakings, many companies got electricity contracts, supply of electricity contracts. Now, these contracts, these electricity supplies, generators were supposed to, they had entered into contracts for supply of coal from Indonesia. Now, because these were all very long-term contracts, the Indonesian companies and government and these companies entered into long-term contracts for supply of coal, and obviously the price of coal was very cheap in Indonesia, so everybody went and made a beeline for supply of coal from Indonesia. But then the Indonesian government suddenly one fine morning imposed a huge levy on the coal which was being exported out of the country. Now that actually pushed up the production price of the electric power considerably. So the question arose before the Supreme Court, when the price of coal has gone up so considerably high, which is a basic raw material, a fuel which goes into the manufacture of electricity, whether these parties can be absolved of their obligations to supply electricity because of such high increase in the input costs. Now, the Supreme Court said no, because the principle was, the Supreme Court says, mere fact that it became more onerous on the party to discharge its contractual obligations. It became more expensive for them does not constitute a force majeure. It is not a frustration. It is not something which would attract the doctrine of frustration of the contract, because that is a risk that you take. So we go back to the old English law saying that, so what? You knew that it could happen. You never had a guarantee that your power, your coal supply would be always done at a particular price. The Indonesian government was not a party to your contract. So you have always taken that risk. You can still supply the electricity. You may have to pay more, but so be it. You have to comply with your obligations under the contract. Now, in this judgment, of course, this was a judgment by Justice Rohinton Nariman. So he would have definitely mined out several interesting case law from various other jurisdictions. And yes, and the other judgment that he referred to in this case was called, it's a very difficult to pronounce name, probably a Greek name. It's Skarigolu and Company Limited was nobly be it something. Now, nobly, this was a case, it's an interesting case. What happened? This is the judgment of 1961, an English court judgment. Now, what happened here was that there was a contract for supply of a shipping contract for supply of goods. Now, groundnuts, that is groundnut. So the supply was to be made, and the normal route of from the port of Sudan to Germany, and obviously from Hamburg to Germany was the supply route. So the route is obviously through the Suez Canal. So unfortunately, the Suez Canal got closed. So the party, which was the performing party, claimed that, see, the Suez Canal has closed. So how do I supply? I can't supply. So the English court said, well, that is not a ground for frustration, because you can still make your way to Hamburg through the Cape of Good Hope. So you have to you have to go around the whole African continent, and you will have to take that detour. It may result in the freight charges going up 10 times, but so be it. It does not render the contract impossible of performance. So when you talk about impossibility of frustration, it has to be something which renders the contract itself impossible. Because if there is no other alternative route, if suppose the plaintiff was able to show, or the defendant was able to show that, see, there is no other alternative route through which I could have got these goods to Port Sudan, then he would have succeeded. And that was the only route through which I could have got this. And obviously, if it was a shipping contract, the other party cannot say you can bring it overland by trucks, because that was not a mode of transportation. So impossibility means it is a shipping contract. Yes, if the Suez Canal is closed, there is still an alternative route. The other part of the story is that, yes, the shipper can say, sir, there is no other shipping alternative. There is no other way. This is the only way. And I obviously cannot ship these goods by overland, by trucks. So that's the kind of impossibility that we talk about. That's the kind of frustration that the force majeure envisages. And then there is another very interesting case. This is Edmonton Commercial Corporation versus Slaviris Rus. Now, this is again a very interesting case. Here, what happened was an oil tanker ran aground near the mouth of the Karachi port. And a salvage company was contracted to salvage the oil remaining in that oil tanker. So the salvage company hired a ship called Sea Angel. This is a very famous judgment. Now, the Sea Angel was chartered, and the period of charter was 20 days. So within 20 days, Sea Angel was supposed to remove the salvage that stricken ship and remove the oil out of it into another ship. Now, Sea Angel did its job. Now, after it completed its task within the time period, the Karachi Port Trust authorities detained the Sea Angel and said, you have to pay us our charges. You have not paid. Now, this company, the Sea Angel, they of course had to get the ship was under detention for a long period of time, and finally it was released. Then Sea Angel went and told the salvage company, the Slaviris Rus, that now please pay us our money. Please pay us for the detention as far as the work that we have done. Now, Slavaris refused to pay, saying that no, there is a frustration. We can't, you were detained there for such a long period of time, so we will only pay you for the 20 days of hire. We will not pay you for the period beyond that, so we are not liable to pay you. And because you were detained by the Karachi Port Trust authorities, so therefore, as far as we are concerned, this is a case of frustration. You got yourself arrested by the Karachi Port Trust authorities. We will not pay you. Now, here the court said, no. You see, the point here was Sea Angel performed its part of the contract. Within that 20-day period, it salvaged the oil from the stricken ship and delivered it, and it has performed its part of the obligation. And the contract between the Sea Angel and the salvage company covered a situation where the salvage company was liable to pay for all charges incidental to the charter of the ship. And there also the court said that, see, when they have performed the principal contract, the contract stands performed. So if they have performed the contract, you can't then come and say that there is a frustration. The contracts to discharge completely by Sea Angel. So they are liable to be paid, and you can't claim, you can't seek a defense of frustration in a situation like this. So for the frustration to be applied effectively, it has to be proved that the very basis of the contract has been altered or undermined by events unforeseen and not contemplated by the parties at the time of entering into the contract. Now, the corollary to this is that if the defendant is able to establish that the party pleading force majeure or frustration was already in default prior to the force majeure, then this plea is not applicable at all. So somebody who's claiming force majeure has to be above board. If the other side was able to show that the person showing force majeure who wants to put up the defense of force majeure himself was in default, then he can't claim force majeure at all. That we saw in the Calcutta case, the requisition case also, there the party was at default, so they could not get the benefit of force majeure. Now, you see, this kind of the principle of Sea Angel, the principle of law laid down in Sea Angel is being followed all over the world, and it has actually all these cases, as you see, were cases where force majeure could not succeed. Now, what happens to COVID now? You see, the COVID kind of a force majeure situation, not a legal force majeure. I'm talking as COVID as a force majeure in our ordinary parlance. Now, what is its implications to the world that we live in? Now, some of the people may try to say that, see, this is a pandemic of an unprecedented nature. The WHO has declared COVID-19 to be a pandemic. So what else do you need? Something that applies across the world. Now, one thing that you all need to keep in mind is the WHO, when it gives a declaration of a disease as a pandemic, it has no legal character. It is only an advisory. The WHO does not make a law. It is just an organ of the UN. And when it says that we are declaring COVID-19 to be a disease, it is something of an advisory. Now, how you treat this advisory, how countries deal with this advisory is entirely their own domestic affair. They may deal with it in a very aggressive manner. They may be relaxed. They may be cautious, etc. That is entirely for different countries to deal with the situation. And so therefore, according to me, when WHO declares COVID to be a pandemic, it really has no consequence on existing contracts. It has no value on the contracts. Now, what about India? Now, what about what happened in India is now to be scrutinized very closely, and this is very relevant because there are certain interesting developments which has happened in the last 2-3 weeks, which I'll refer to. Now, you see, on 24th of March, the central government issued a notification under Section 3 of the Disaster Management Act, issuing directions to the ministries and departments and state governments and union territories to deal with effective steps to deal with the pandemic. So the government of India has dealt with this particular pandemic as a disaster. It is treated as a disaster. Now, on the same day, that is 24th of March, they also issued series of guidelines which indicates what are the things which are permitted and which are not permitted, what activities can go on, what cannot go on. In fact, nothing can go on. There were only exemptions. Everything was everything was stopped. Everything was banned. Every activity was banned. Only exceptions were carved out in that guidelines. Now, in the wake of these notifications, various government departments and ministries have also issued executive orders so as to make sure that existing contracts are taken care of and there is no claim for compensation, etc. So they have issued appropriate orders saying that no force majeures can be applied or invoked for existing contracts, etc. But these are all matters relating to government contracts, contracting with private parties. So the whole idea was to protect the government from facing any claims based on force majeure happening, etc. Now, Reserve Bank of India has also issued guidelines and circulars to financial institutions how to deal with loans and loan repayments, etc. Now, you see, what happens is that in spite of all these things, the fact is that as far as the private sector is concerned, this would have an implication. Their contracts would get affected. Now, something as basic as this, let us say an event management company has been paid 100% upfront by a girl's family for conducting a wedding, and they have paid the amount upfront for, say, conducting a wedding for 2,000 people, and the wedding had to take place, let us say, sometime in April. Now, what happens to that? Can the girl's parents ask for a refund of the money? Would they be entitled to ask for a refund? Would the event management company claim frustration and say that we are not at fault? You can't ask us to pay up. We have already paid some money to the caterer. We have also paid some money to the decorator, etc., etc. In my view, these kind of cases would definitely be covered under force majeure, but not covered under force majeure because a date of marriage can be rescheduled. You can't allow somebody to appropriate the monies just because something has happened. That's the situation that the courts will look at. Is somebody trying to take undue advantage of a situation? You can't allow people, unscrupulous people, to take undue advantage of a situation such as this. So obviously, an event management company cannot claim force majeure in a situation where the nature of the contract is such that it can be renegotiated, it can be postponed. It's entirely for the girls' party to find out another day and to decide when it's to be done or not to be done at all. These are all matters which can be taken care of. Now, you see, I was just telling you as to the interesting aspects of what has happened post the central government notification. You see, there are two cases, one from the Bombay High Court and the other from the Delhi High Court. Now, the Bombay High Court judgment was both these cases related to invocation of bank guarantees. Now, the Bombay High Court, in this case called Standard Retail Private Limited, it's a judgment order of 8th of April, where a party approached the High Court seeking the stay of invocation of a bank guarantee on the grounds of the pandemic being declared and the central government notification. The Bombay High Court refused to stay the invocation of the bank guarantee, saying that I do not think that this is a case where there is a frustration, etc. I do not see any situation where Section 56 or Section 32 of the Contract Act is attracted. There is nothing to show that there is an impossibility or a frustration. So the Bombay High Court refused to stay the invocation of the bank guarantee. 2 weeks after this judgment, on the 20th of April, the Delhi High Court, on an identical situation, stayed the invocation of the bank guarantee. So this will give you an indication as to how the law on force majeure can be so different. I mean, there is still so much of uncertainty. It all depends on how well are you able to analyze, how well are you able to take a plunge into the contract and find out a way, depending on which side you are. If you are somebody who's pleading for frustration, saying that this is a frustration, you will have to demonstrate it with the help of facts at hand. And if you are a person who's defending a claim of frustration equally well, you need to master the facts of your client's case. You never know, there could be some bits of pieces of facts which will help you deal with your client's facts and situations effectively. So it's a very, very interesting area, and a lawyer needs to be very, very alert to while dealing with these kind of cases. Now, interesting, there is a very, you see, Hong Kong is such a small territory, and it would be surprising to know that though it's a part of China, they seem to have a judicial system which follows the English law, probably because of the transition period, when I think in another 30 years or so, it becomes entirely a part of China. There is one case from the Hong Kong court, which is going to become very, very famous, because this is the only judgment which deals with the question as to whether a pandemic is a force majeure event. This is the only reported judgment on this particular issue. Now, this judgment, the name of this judgment is Li Qingwing versus Zhuang Ziong. Now, Li Qingwing is a landlord and Zhuang Ziyong is a tenant. Now, what happened in this case was that the landlord was the owner of an apartment in Kowloon, and it was a lease for a period of 2 years. Now, the defendant, the tenant, was staying in that flat with his family, and in 2002, lease was in 2002 for a period of 2 years, that is up to 2004. Sometime in 2003, there was an outbreak of SARS. This was the Chota Bai of COVID. There was a SARS outbreak, and just like the present day times, there was a lockdown order issued by the Hong Kong Department of Health. Everything was shut down. There was an isolation order, and this particular block where this property was situated was under lockdown, and it was under isolation. It was quarantine. And because of the quarantine order coming in, the defendant moved out of this property and moved into another property. And then he later on, the tenant issued a notice terminating the lease. And he said that because this was under isolation and quarantine, etc., I don't want this property because of the SARS outbreak. There is frustration, therefore I am not liable to pay any rents, etc. Now the landlord went to court and said that no, how can he terminate my lease? He said that this is not a case of termination of the lease. He can't terminate it. This is not a frustration. This is not a force majeure event, because the lease was for a period of 2 years and he has already lived there for a considerable period of time. And the only period where he was not able to live there for the disclosure order was only for 10 days. So this 10-day period is completely insignificant, is absolutely insignificant in relation to the entire duration of the lease. So this is not a case where you can plead frustration. And the court upheld the contention of the landlord and held that the tenant is liable to make the payment for the entire remaining period of the lease duration. So this is the only case on the issue of pandemic as a force majeure. And in that particular case, it was held not to be. Now, likewise, as I foresee, we don't expect to see this lockdown continuing indefinitely. Sooner or later, it will definitely be lifted. So most of the contracts may be able to survive this pandemic. But there could be cases, there could be contracts where time was of the essence. And if suppose something was to happen, you needed a particular goods to be delivered for a particular event or some particular commissioning which was supposed to take place on a particular day, which could not have been pushed off. And if something like that gets hit by this lockdown order, then surely this defense would be available. So this is an unprecedented period of time, and we will definitely see a lot of cases coming up where this particular defense would be raised. Now, you see, there is Another very interesting case which I wanted to refer to, that is, this was a case relating to, the lease of a property in Canary Wharf in London. Now, this is a High Court of UK judgment. This is a very recent judgment of 2019. It was also a tenancy matter where the tenant was an agency of the European Union who had taken the lease for a term of 25 years. And that is when the UK gave its notice under Article 50 for intention to withdraw from the European Union. And the tenant took the proceedings that the UK's withdrawal would frustrate its lease on the grounds, amongst others, that it would no longer be lawfully able to exercise its rights conferred to it under the lease, including the right to occupy the premises or to assign. The judge rejected these arguments and said that the changes brought about by Brexit do not render the tenant's occupation of the premises impossible and did not render the tenant's performance under the lease something radically different. So you see, this according to me is not a, of course, I don't really see this judgment to be very sound, because you see, if the European agency has taken the lease for the purposes of the working of the European Union, and the lease contained certain privileges that the tenant could exercise as the European Union member, then surely the judge was wrong in saying that the tenant can still render the premises, it does not prevent him from occupying the premises. But the whole object of the tenancy, and the landlord was aware of the fact that the tenant has been given the 25, has taken a 25-year of lease because of certain presumptions and assumptions. But that being the law, you have to accept it. The judge in his wisdom has held that this does not prevent the tenant from continuing the premises for a period of 25 years. You can use that period of 25 years. Who's preventing you from doing that? Whether UK remains part of the European Union or not, you are still entitled to use it for your tenancy purposes. Now, one of the issues which could arise is that, this long period of lockdown and the uncertainty of employers and employee, what would happen to your employment status? You see, this is a very different kind of an issue, because you see, an employment contract is different from other kinds of contracts, because employment contracts are contracts at will. You can hire services. Usually, these are contracts where the parties are at liberty to terminate the contract at any given point of time. The reason being, you are dealing with human beings. These are not goods. You are dealing with human beings. This could be a contract for service or a contract of service. A contract for service is a contract where you engage somebody for services, like a lawyer's services being engaged, because he has a specialized skill, you or an architect being engaged. These are all called contracts for services. And then you have contract of service. That is a normal contract, that your employer-employee relationship. And these contracts would normally contain a stipulation that it can be terminated by 1 month's notice on either side. So suppose, assuming that a particular employer says that, it's no longer viable for me to keep you in employment, he will issue a simpliciter letter of termination. The employee cannot come and say that my termination is bad. This is not a force majeure, and therefore I'm entitled to continue in service, or he cannot file a suit saying that I am entitled to compensation, which is the salary I would have drawn till I attain the age of retirement. You can't do that, because this is an employment is a contract at will. You are free to do it. You can terminate at any point of time. So, as unfortunately, I would also find that yes, employment contracts may be terminated. Force majeure will not really help them, because sometimes the employer may be justified. It is the employee is supposed to generate revenue. It's a marketing company. Unless the people are able to go out into the market and sell the goods to generate income for the company, you will not get an income, and in turn the salary and wages. So if the company is under closure, not because of its own doing, because of an order of the government. How do you ensure the employment is generated, revenues are generated? How do you pay your workforce? So those kind of employment contracts, clearly there could be enough justification for sustain the termination. And the same thing would be applicable to travel industry, hospitality industry, etc. Unfortunately, that is the reality of the present day situation. Now, you see, the last I also wanted to take this opportunity to. This is meant for lawyers. Now, you see, a COVID-19 situation is an unprecedented situation. It has thrown up all kinds of challenges. It has never happened in the history of mankind, at least not happened in the history of the modern world. Now, if a client comes to you, I'm sure many of us will look at it very realistically and logically, rather than sterile, in a very sterile legalistic manner. You will also have to think beyond the mere law. You will have to also advise your clients, see, okay, you could use force majeure, or you may not relent to relaxation of time. You are entitled to say that no, this is not a case where I will give any extension of time, force majeure or not. You will also have to see in the long run if this has resulted in a complete disruption of economic activity and business, and income generation, and the economy itself has come to a grinding halt. That will have a long-term implication. So lawyers, as responsible members of society, have to advise their clients in a more realistic, in a more wholesome manner when they have to deal with a client walking into their office with a force majeure issue. You have to say that negotiate, please deal with this situation realistically. You may go to court, and of course you will also advise your client on the possibilities of success or not succeeding on a force majeure defense or a force majeure point of argument. So this is something which has to be seen very, very realistically. And all that I can say in conclusion is that we don't know when the COVID-19 vaccine or a prophylaxis will emerge, but your sound advice to your clients can act as a vaccine or a prophylaxis in these challenging times for the client. Thank you very much. So I am ready to take questions. If you have any questions, need not be purely legal. If there are some non-lawyers in this group, they can ask questions that really concerns them. Or if, of course, you are also entitled to ask for any question relating to the law. Thank you.
So we've received a few questions during your conference, and I'll proceed with asking them. The first one is with regards to the aviation sector, and the question is whether airline companies or conglomerates can invoke force majeure to seek exemption from paying parking charges or other bay charges, maintenance charges at respective airports, because a lot of aircrafts are stored away there right now.
Yeah, this.
Abhi, can you ask Naveen to come onto the main screen and then switch this off?
Yeah, okay. Just one moment. Just one moment. Is this fine?
So now you're on the main screen. Yes, sir.
Yeah. You see, this is I in my assumption, my assessment is airport lease agreements with airlines and airlines lease agreement with their leasers. These would be typically the hell and high water agreements, where there will be no room for any force majeure defenses to be put up. Because this is part of the industry standard. It's an industry standard. So it is very unlikely that these kind of contracts would contain any force majeure room, any room for maneuvering on force majeure. These are hell and high water contracts, because airlines get a particular slot in the airports, which are difficult to negotiate, which are difficult to get. And somebody who tries to get out of it will lose that slot forever. So most of them would not be able to get any leeway on this score, is my opinion.
Yes, sir. So our next question is regarding perishable goods and the legality thereof. So the question is regarding if there is a if there is a lockdown restriction in place, and the government is allowing services to be imparted and services to be given to consumers
Yes.
within a state itself,
Yes.
but they're not allowing any help. Is there any remedy to enable access of supplies from across the state lines? Because right now states have their own restrictions, and the central government, they're all obviously following the central government restrictions.
Yes. So yes, you see what has happened is the central government notification has given it to left it to the state government to develop their own guidelines as to deal with those principal industries and business operations which are permitted. So it depend on the seat of the contract, the subject matter of where the parties are situated. For instance, if it is a contract for supply of perishables from Haryana to Uttar Pradesh,
Yes, sir.
one party is in Haryana, the other is in Uttar Pradesh. The supply has to be made in Uttar Pradesh. So unless the party is able to make a point that the goods had to originate from Haryana, there was no provision for the transportation of the goods across the border from Haryana on to Delhi or to Uttar Pradesh. If he is able to show that there was a clear bar, because it's a statutory bar.
Yes, sir.
So then that would be a case where he can invoke the doctrine of frustration and say impossibility of performance. It would be a section 32 situation, or and 30 and 56 as well, because movement has become illegal because of the action, because of the notification issued by the Haryana government. There is a complete closure of the transportation across the border by executive order or by a statutory notification. That would be a clear ground for claiming frustration.
Yes, sir. So the next question is towards furnishing of bank guarantees. So there's a query regarding a hypothetical case scenario where a bank guarantee has been furnished for performance as well as security deposit, which is normally around 10%. And bank charges for such guarantees are generally very high. For ensuring such guarantees are very high. Now with this lockdown in place, can a buyer, can one make a request to the buyer under a force majeure clause to waive off the days so as to enable them to get some reprieve?
Yes, this is a very good question, because according to me, these kind of situation would arise very often now, from now onwards.
Yes,
according to me, this is a situation where the parties can renegotiate. Obviously, you understand that. See, as far as legally speaking, exactly what I was saying. Legally speaking, the bank is under no obligation to assess whether this is a force majeure event, whether force majeure is attracted or not, because the law is very clear. Bank guarantee is something which concerns the mandate given to the bank. It is not required to look at what the actual contractual issue is between the parties. But in a situation such as this, the principal contracting parties can renegotiate the terms, where the party extending the bank guarantee can say that, yes, I may incur some additional costs, but I am willing to furnish the bank guarantee, but please give me these concessions. Because otherwise what happens is, if the bank guarantee gets invoked, then the whole contract goes into another direction. You will be more focused on getting that money which has been collected by the other side by invoking the bank guarantee. So this is actually a situation where a lawyer can advise his client appropriately and say that, yes, please renegotiate, and put it on the record, put it to the other side in writing that this is what has happened. You know it very well. So let's have a renegotiated contract, and please instruct the bank, please ensure that you don't invoke the bank guarantee, don't call upon the bank to release the funds. So this is actually how it should happen.
Yes, sir. So our next question is regarding a radio station. Now, a radio station is operating obviously on a licensed premises, and it's seeking a rental waiver and maintenance waiver. They're continuing to operate their business on a very restricted scale. So the question is whether under grounds of force majeure, if they can claim this waiver.
Well, legally they cannot claim because they were functioning. Now, you see, this is part of an exempted activity as far as the notifications go, because this is part of the electronic media, which are anyway not exempted from operations. And admittedly, if they were on air during those entire period of the lockdown, and there was no legal impediment on their carrying out their work, whether they actually run the studio or not is of no relevance. The test that the courts would apply to see is whether there was any prohibition which disabled you from operating your studios. Now, legally, they were not disabled. They were actually running. So that would actually not. But yes, this is also one of those situations where you could negotiate the terms with the landlord and say that give me a partial relaxation of rental for that period, or allow me to pay a deferred rent for that period because I have no revenue coming in during these days, etc. So obviously, this is a matter which you could actually negotiate. But legally, no, you can't claim waiver.
So the next question is towards the fundamentals of contract. The question states whether a contract can be enforced when both parties are aware of this inevitability, which is COVID-19, and though this is not a part of or it doesn't fall under the body of the contract, whether a contract necessarily becomes enforceable even though both parties are aware of such an eventuality, which has arisen.
This is covered by section 56, which says that if the unforeseen situation was actually known to the parties, then that contract is actually not enforceable. And the party who has suffered, I mean, the party who was actually, of course, if both parties are aware of it, if both parties are aware of it and they expected the contract to be executed regardless of the COVID-19 situation, then it's an enforceable contract because both parties have given up.
Yes.
But the other situation is when one party is not aware, the other party is aware. Then the party who was not aware, but the other party was aware. For instance, if suppose somebody is trying to sell his land which was under acquisition, there is a section 4 notification, preliminary notification or acquisition. The buyer doesn't know about it, and then the landowner is trying to sell a land under acquisition to the other person.
Yes.
Now, other person has paid an advance. Then he could come and say that, boss, you have not told me about this. I was not aware of it. You were under a duty and an obligation to tell me about this. So this was a situation where you can actually say that the section 56 says that in such a case, the seller is liable to pay the entire amount back to the buyer because he suppressed a particular fact. But in a situation where both parties are aware of the risks, then it is a valid contract because there is no disability on either side. Both of them, it's an enforceable contract because the ground would be an argument of force majeure will not be available at all. Because both parties are aware of the situation. They are aware of they have foreseen the risk.
Yes.
The interesting part is that the force majeure will arise only in case of an unforeseen event happening. Where the event is foreseen, you have seen the risk, it is force majeure does not get attracted at all. That would be the answer.
So the next question is regarding small scale businesses. Say it is a grocery store or it is it's providing essential services. So they still have this supply chain which is in place. Now, any small business which is not dealing with such a particular service, which is say essential service, and their supplies are obviously not coming in place, whether they can terminate their contract and whether they can claim repudiation of a contract under this particular situation of COVID-19.
Contract for what?
For any services that for any supplies that they purchase from a wholesaler, for example, and it's not an essential service.
Of course they can. These are all very flexible contracts. That's the standard that we know of. There are no written contracts, etc.
Yes,
it is obviously, it functions on a demand supply scenario. If somebody if milk powder is in great demand, so the retailer would place a bigger order on the wholesaler, and if it is if the demands have gone down, he'll scale down the order. It's always on a requisitioning basis based on demand supply situation. So that's the industry standard. So one would say, well, I am entitled to scale down my my quantities because this is retailing.
Yes.
Retailing is always based on demand and supply situation. There is no fixed quantity contract. But larger contracts are always, you give an undertaking that the contract says that there is a minimum guaranteed quantity that I'll buy every month. Those kind of contracts, of course, would be enforceable.
Yes, sir.
That's the situation. No, but let me just develop on that. Let us assume that there is a contract where they say that the contract says that you will take a minimum of this much of quantity every month, regardless of whatever. Now, for that, suppose later on he says that sorry, I will not be able to take because of COVID situation. I am not obliged to perform that part of the contract because of COVID. It is a case where you can make that case good. The person who's saying that I can't be forced to take that quantity because of the situation that the transportation was not available. It's not a factor which I can regulate. So yes, these are all flexible issues, and depending on facts, you will have to show the particular facts, and you will definitely, on the basis of evidence that you read, you can always show that yes, this is something which is frustrated. I couldn't have taken the quantities even though I wanted to.
Yes, sir.
Yeah.
So we have another unique scenario wherein it's not a unique scenario, but it's a different case itself regarding legal positions of agreements to sell. It's an unregistered agreement to sell with respect to an immovable property between a buyer in India and the seller is abroad. And this agreement to sell is prior to the lockdown, and the seller is unable to discharge his obligations due to the lockdown being in place. So whether the buyer can cancel this agreement and also claim for a refund, as there is no end in sight right now. There is no force majeure clause in this agreement.
Good. So this is like our Calcutta case, the first 1954, the Bangur case.
Yes, sir.
The court will look at this, court or the parties to this particular contract would have to look at it in this manner. Yes, the seller was unable to travel to India to execute the lease deed, but that does not mean that the contract is incapable of being performed on a future date. So this is a case where the parties can, by an email, extend the period of execution. The deadlines can be executed, but it would not render the contract impossible of performance. This is a Section 32 situation where the contract itself indicates that yes, the seller stays abroad, the buyer is in India, the seller is expected to come down to India to execute the sale deed. He is not able to come because of the lockdown and the ban on flights across the world. But that is not a situation where because the property is very much available.
Yes.
See, it's not a case of the property getting washed away in a flood or getting burned down. The property is very much available. Subject matter of the contract is the property. And the parties have intended to, one party wants to sell it, the other party is willing to buy it. So both parties can't walk out of this kind of a contract.
Okay, sir.
Unless they mutually agree, it can't be. At the instance of either party, the contract can't be simply terminated. You can't terminate it.
So our next question is from the facet of cross-border trade between China and India. So the query is regarding finished goods and the supply thereof from China to India. Now, China had a lockdown in place in January. And in India, the lockdown only came in March, towards the end of March. So what will happen to such a contract regarding supply of finished goods when they come from a cross-border state where there are differing periods of lockdown?
Okay, so this is a situation where let us assume that the suppliers dispatch the goods once the lockdown in China gets over.
Yes, sir.
And the Indian Indian party who was supposed to who has ordered the goods, unless he's able to show that the delivery of goods was stipulated on a particular date, and on that particular date, the date had some relevance, and the relevance is known to the supplier, that yes, this had to be commissioned on or before the 24th of March. We had a commissioning to be done, and because the government had by law required us to commission that particular plant by a particular date, failing which we would have to suffer irreparable consequences. Our license would have got cancelled, etc. Such serious repercussions if the timely supply of goods was not received. Then in that event, the Indian buyer can say that, see, as far as I am concerned, because of your lockdown, your inability, why should I suffer? because now, because of you, you have dispatched the goods at your convenience. Whereas the nature of the contract was that you very well knew that this has to reach me by a particular date for this reason. But let us assume it is a normal, simple contract where goods were, orders were placed for supply of finished goods, and they could not be delivered within time. Then the court will look at this from a perspective of whether time was of the essence.
Yes, sir.
If time was not of the essence, how does it matter when you receive, whether you received it in March or whether you received it in May? Nothing would have happened, and the other party, the supplier, is not aware of the fact that this time was of the essence. It's a normal industry practice that yes, you have ordered 20,000. For instance, let us say the order was supply of ventilators, and the government wanted ventilators for putting up a COVID care center, exclusive center at a particular place, and they wanted it to be commissioned in anticipation of the peaking of the disease.
Yes,
and suppose they delivered it sometime in September, then surely you can invoke this particular point that this contract is frustrated.
Yes, sir. Because time being of the essence.
Yes, the nature of the goods and that the circumstances under which it was placed, that will all become relevant in such a case.
So there are a few queries regarding rental waivers, whether they are essential service providers, whether it is residential owners. So what is the way out for them when they are claiming rental waivers? And it's an essential service, for example, which is functioning.
Let me put it like this. So we are actually embarking on a virgin territory, because this is all come up in various forms out there. I'll give you an example.
Yes, sir.
Now, you have the office of a lawyer's office, a rented out office, where a lawyer is operating out of a rented premises. It could be a chartered accountant, it could be a architect, it could be anybody else, any independent practitioner or a professional services.
Yes, sir.
Now, this lockdown obviously prevented most of us from going to our offices. Suppose we were living in a rented accommodation. Can the lawyer say that since I was not able to use the premises, why should I pay you rent? So that is one situation. The landlord would of course say that, you could have you were able to operate from home as well. So your work does not get affected whether you are working in this office or from your home. But take the example of a beautician or a beauty parlor. Now, somebody who runs a beauty parlor actually has the equipment, or a hairdresser, he has a salon, and he works, he can make money. His profession depends on the site of his work. Unless he gets to his parlor, he can't work. Now, in such a situation, this second category of people, they would definitely be in a position to argue and say that very well that the lease is for running a beauty parlor, and this particular parlor is situated in a mall, and malls have been shut down by the government by a general order. Yes. And I could not operate my parlor, so why would I be liable to pay you rent? So this period of closure, when the mall was shut down under the orders of the government, and I was unable to discharge my business because of that, so you are surely not liable to charge me rent for that period, because this is by an intervention of the government. Yes, because of the pandemic. So it can very well be argued that I am not liable to pay rental to the landlord for that particular period if the nature of your services are such.
So there is another situation which has arisen regarding purchase. I'll just read out the facts, brief facts. There is a company which had bagged an order for belt conveyors for a private for a power plant, and the power plant is a government company. Yes. They had bagged this order from an EPC contractor, which is a private company based in Hyderabad.
Okay.
Then they're paid 10% advance for which the engineering company had furnished a bank guarantee. Now, part order had been supplied, and the balance or quantity has been made ready. Now, the party has not lifted any material for the last 2 years, and instead of paying any bills, they're just trying to revoke the bank guarantee furnished against the advance. So can the company itself take action against the revocation of the bank guarantee?
Yes, of course. Of course, this is not a situation related to the force majeure event, because the relevant facts preceded the outbreak of the disease, because the company says it had actually fabricated the equipments much prior in point of time, and
Yes.
the government department did not actually lift the goods. Uh, of course, you can. This is a matter which has to be decided on the facts of the case. One will have to go into all fine aspects on the dates, when it was, what was the communication. There is a lot of evidence to be looked at, and this is definitely not a kind of a force majeure situation, because if the event of default is preceding the outbreak of the pandemic,
Yes, sir.
then nobody can claim the benefit of the pandemic in this kind of a situation,
Hmm.
because a government department which is supposed to be lifting the goods can't claim the pandemic as an excuse. Neither can the supplier say that they are supposed to pick this up, because if something has happened prior in point of time, the events
Yes.
of the relevant events of default, or the events on which you say that you have executed the contract is predating the outbreak of the disease, then surely the force majeure arguments will not be applicable to a case like this. Yes, this seems to be a normal contractual dispute of an engineering contract, where you place an order and then paid in advance. You fabricated some of the equipment and then they did not pick it up, and they're threatening to invoke the bank guarantee. The law on bank guarantees is very clear. Bank guarantees can be invoked unless there is some egregious fraud.
Yes, sir.
That's the law. That unless there is some fraud which was withheld, something which is withheld, not known to the party, not withheld from the party who had furnished the bank guarantee, the bank is under an obligation to honor the request for the invocation. Yeah.
So the next,
and we all know, as lawyers, we know that getting a stay of invocation of the bank guarantee is next to impossible.
yes, sir.
Yeah.
So the next question is related to resort bookings. Now, if it's done on an online platform, say booking.com, or it's done via Airbnb, and it was done for a period which now falls in this lockdown, and Airbnb has its own policy in place, obviously, for such refunds. However, is there any claim over and above this policy, and distinct and separate from such a policy which Airbnb may have or booking.com may have, wherein we can request the resort to refund this particular payment that we made?
Okay, this is a good question, because most of us don't even look at the terms of the booking, because these platforms like Airbnb and booking.com, they are mere intermediaries, and we would not look. Of course, they collect the money which you pay,
yes, sir,
and they pass it on to the resort while retaining their profit. Now, these are all cases where, because of a supervening event, if you are not able to travel to the destination or check into the property,
yes, sir,
according to me, you have a good case to claim a refund regardless of what the contract is. Because these businesses are also equally, they know very well that this is something which is not anticipated by anybody. They cannot, the intermediary would say that I have actually passed on the payment to the resort. So the resort will say that I don't have a privity of contract with you, the guest. I am only dealing with you through the intermediary, who is actually your agent.
yes, sir.
So these kind of issues would arise, and there will be a lot of such issues as to who is the principal, who is the agent, who is the agent of whom, who is the principal of whom. So these kind of disputes would arise. But according to me, at the end of the day, this is a business model where you have to consider the interests of the customer.
Yes, sir.
Considering the kind of goodwill and the losses. Imagine if booking.com were to refuse refund to thousands of people who have booked on their platform, the business goodwill is lost forever.
Yes, sir.
It would be, I mean, they would be seen to be so unreasonable. So I am sure they will definitely, regardless of what is their printed contract, the standard form contract, they would definitely have they will have to deal with it in a very different approach altogether to protect their goodwill and the future of their business.
Yes, sir.
Yeah.
So another question which arises is in case of aviation or train travel, for example, some airline companies in India, what they're doing is they're not refunding the tickets right away. They're prolonging it. They're stating that instead of traveling within this period of lockdown, we will allow you to travel on any other date once this lockdown ends. He'll fix you and book you for another date. What will happen where a customer does not want to travel anymore, his requirements are not needed after the lockdown period? Can he still claim a refund when the company is mandating this?
Yeah, okay. So this is, you must understand that aviation, that air travel in India is regulated by statute.
Yes, sir.
So these aircraft, the airlines operate on permissions and licenses granted by the government under law. So they are subject to government directions and directives. And as far as I know, the Ministry of Civil Aviation has issued instructions to airlines to give refunds.
Yes, sir.
So obviously they can't withhold this amount. It is entirely for the consumer, the passenger, to decide whether he wants to defer the travel on a date of his choice or whether he would like a refund. But surely no airline can withhold the amount or say that forfeit the amount which has been paid on a travel which could not be completed on account of this COVID closure. So clearly the airline cannot appropriate the amount. They can't do it. They can't do it. There is a government directive.
So another question we have is slightly general in its scope as well. Now, considering that there is a big economic slowdown already in place, and economic viability of entities is threatened, there is an apparent and clear non-availability of funds due to these exceptional circumstances brought about by COVID-19. What would be the advice for contracts which have already been concluded, even the cases of purchase of property due to paucity of funds now? It will affect one party more than the other.
Yes, yes. Particularly when there is diminution of the value of the property post-COVID.
Yes,
and the buyer may not be willing to pay that kind of money because of the market value has gone down.
Yes, sir.
So this is a very tricky situation. But then what happens if the buyer does not pick up the property? See, if the buyer does not honor the commitment, what would you do? The seller would also have to look at it very practically. He would have to then go to court and file a suit saying that he seeking that he should purchase a property, he should honor the agreement to sell, etc. As far as the buyer is, so that is as far as the seller is concerned. If the buyer wants, he may not. He may forego the initial amount, the security amount or the initial amount that has been paid. But if it's a substantial amount, then the option for him is to try to renegotiate. It is not difficult. If you have a reasonable seller, he would try to realize the situation, but most of them may not. So but definitely these kind of contracts are not written in stone.
Yes, sir.
They are open to negotiation. It is advisable for both parties to try to negotiate and see if the transaction is carried forward, because for the seller to reach the same kind of values, it may take time. There may be a diminution, maybe to the extent of 20%, who knows? So to come back to those levels may take a couple of years. So why would he let go of that opportunity? And if he has already been paid a substantial advance, he will definitely hold on to his horses. He will not let go of it.
Yes,
so
sir.
that's the kind of situation we are looking at. But surely in such a situation, one way could be that prolong the period of time for executing the sale deed, allow the buyer to arrange for finances over a longer period of time, make agreements, rework the agreements in such a manner, be somewhat creative and think out of the box, give that cushion to the buyer to arrange for that funds, which may not be available to him today as it was available prior to COVID. So you have to come out with these kind of innovative measures to ensure that parties can get some kind of comfort, some kind of margin, to get over the situation.
So would you also extend this advice to small businesses where they have entered into contracts with, say, suppliers or other
Yes,
entities in the intermediary chain?
absolutely,
Yes,
absolutely. It's prolong the period of time.
yes, sir.
Everything should get prolonged now.
Yes, sir.
When the distance between human beings can be increased to 1.5 meters. Why not the period for making payments?
Yes, sir.
Natural. You need that space now than ever before.
Yes, sir.
Very important.
So those were the questions for today's session. I
Yeah,
just want to thank everyone. I want to thank Sir
yeah,
for his extremely enlightening discussion on this pandemic and the situation of contracts.
yeah. Thank
Um,
you very much. Yeah.
Thank you to all our listeners today as well.
Thank you everyone who tuned in, and we hope to see you again on the next topic, which we will be posting shortly.
Next topic is most likely Abhi is on arbitration. I think it's on Tuesday.
Yes.
Okay.
The next session will be arbitration law and its situation in the COVID and subsequent to the COVID-19 pandemic. And this will be on Tuesday. We'll post the details on the group itself and we'll keep everyone informed. And yeah, thank you so much.
Thank you very much. Thank you.
Thank you.
Thank you. Yeah.